This is Caught in the Act with Tim Clarke.
Welcome back. On 15th of February 2021, Network 10's flagship news show, The Project, began their episode like this.
Welcome back to this special edition of The Project. Tonight, claims of rape, roadblocks to a police investigation, and a young woman forced to choose between her career and the pursuit of justice. And it all happened right in the heart of our democracy.
The presenter of the show that night was Lisa Wilkinson, the young woman making the shocking allegation that she had been raped inside Parliament House in Canberra was Brittany Higgins, and her alleged rapist was not named. But, according to him, and latterly his high-powered and highly paid legal team, anyone who knew him or Miss Higgins would have put the clues together in mere minutes and come up with his name, Bruce Lehrmann. Those allegations sent shockwaves through the Canberra bubble, which quickly rippled across Australia. The Me Too movement in this country had one of its most significant moments, and the allegations, as they were, set off a chain of events which have had a seismic impact at the highest levels of politics, the Liberal Party and the law in Australia ever since. The subsequent criminal prosecution of Mr. Lehrmann went ahead in Canberra, but then fell over in spectacular fashion last year. The prosecutor in the case declined to retry Mr. Lehrmann and then lost his own job over his conduct. And now it is Mr. Lehrmann making the allegations that Network 10 and Lisa Wilkinson defamed him in the most serious of ways. That matter went on trial in Sydney's federal court this week and will be heard for weeks to come. And the first few days have already produced some bombshell moments. And so, to help me walk the line in the case of Bruce Lehrmann versus Network 10 Proprietary Limited and Lisa Wilkinson is specialist defamation and media lawyer Nick Stagg, co-founder and principal of the law firm Steedman Stagg. Thanks for joining us, Nick.
Yeah, thanks very much, Tim. G'day, and I'll just say up front, it's a real pleasure to be joining who I regard as one of Australia's sort of preeminent and best respected court and legal affairs journos. So I'm happy to be here.
Thanks, mate. So, as defamation trial goes, this one is about as high profile as they get.
Yeah, Tim, look, it sure has attracted media attention, online attention, clearly as a result of the incredible focus and attention the criminal trial received and the lead up to that matter, and of course the political machinations and the reporting on that. There is no doubt about that. But of course, you know, we've had a number of, as you described, high profile defamation trials in recent times. The Ben Robert Smith trial, defamation trial, of course, was not that long ago. Mm-hmm. Heston Russell only within the last little bit. Mm-hmm. Jeffrey Rush, Rebel Wilson, and of course more locally Mr. Lloyd Rainey's had a successful defamation trial against the state. So there's been a number of them lately.
Mm. And this one has already been referred to this week as a de facto rape trial because a lot of the allegations are similar to the criminal proceedings, and at the heart of it all is the truth about an alleged sex assault. Would you go along with that labelling?
Look, it's certainly it is one element of the case, that's for sure. Of course, there are a number of other key issues that the trial judge is going to need to deal with. Coming to determination. Of course, one of those is around the question of whether or not Mr. Lehrmann was in fact identified by the publication. My understanding too is that there are qualified privilege defences that are at play. Or in play, and there's to be evidence and questions that need to be determined in relation to that defence. But yes, in relation to the truth defence that I understand has been pleaded on the 10 Wilkinson side, yes, that question will need to be determined. The question of the substantial truth about the allegation that Mr. Lehrmann sues on, which is that the story suggested that there was an alleged sex assault in play. So, indeed.
So, while this week's trial is about a TV show in 2021, that TV show centred on a boozy night, attended by a group of political staffers in Canberra in March 2019. That group included members of the staff of Linda Reynolds, the Liberal senator from Western Australia who had just taken over the portfolio of defence industry. That had led to some bloodletting in her office, but two of those to survive were Bruce Lehrmann, a policy advisor, and Brittany Higgins, who was set to be involved in the liaison between the senator and the media. On that night, the group first attended a bar called The Dock before moving to another place called 88 MPH. And then, what is unchallenged is that after that, at around 1:40 a.m, Mr. Lehrmann and Miss Higgins arrived together back at Parliament House. Their arrival and entry is caught on CCTV. You can see Mr. Lehrmann jacketless. You can see Miss Higgins in her distinctive white dress go through the body scanner once and then again after being told to take her shoes off. The security cameras catch them walking to their boss's office. And what happens then, behind that office door, over the next hour or so, was and still is a major Australian political and legal scandal. What Miss Higgins says happened was aired on the project on February 15, 2021.
The first thing that sort of awoke me was I was in a pain. My leg was kind of being crushed. The senior staff was on top of me. He was clearly almost finished.
Sorry, was there sexual intercourse going on?
Yeah, I woke up mid-rape, essentially. I don't know why. I knew he was almost finished, but I felt like it had been going on for a while, or that he was almost done. He was sweaty. I couldn't get him off of me. At this point, I started crying.
What did you say to him?
I told him to stop.
Did he?
No.
How many times would you estimate you said to him to stop?
I felt like it was like on a loop endlessly. At least half a dozen. I was crying the whole way through it. And he didn't speak to me the entire time. I just remember him, eventually, he stopped. And he got up. And he looked at me. And I kind of looked at him. And I couldn't get up. And then he left.
Nick, for a journalist, that is gold star, heaven sent, and like once in a career type of content. But for a media lawyer like yourself, a minefield, I would imagine.
Tim, look, as you know, I once a long time ago was a journalist, for 3 years before starting law. So, now I understand the importance, and I'm speaking generally here, of the importance of getting the story out. And indeed, my role, as I've always seen it, is one to advise on, I give advice, and the editors and so forth will make the calls based on the advice and risk assessments. Mm-hmm. But my role is not to, stop publication and things, but rather to advise on perhaps optimal ways or better ways of sending the message or getting the message that in the public interest, etc., needs to be gotten out there, but with reduction of risk. I mean, people ask me what I do for a living, and I tell them, not really facetiously, that I deal in pessimism. I mean, that's what that's what litigation lawyers do. I mean, we've got our eye focused on risk and how best to avoid it. So, these things are always about assessing those issues and trying to plot a way through it, hand in glove with editorial staff, journos, reporters, etc. So, and one's got to remember the people involved, in this matter, the media, they're very experienced people. The lawyers very experienced. Calculated decisions have been made based on legal advice. I can only but assume, and Tin and Elisa Wilkinson have got their views, and of course are defending. So. All will be revealed in due course. Obviously, as this trial runs its course and we have a decision and any other appeal proceedings or what have you that may follow, So, no, it's nightmarish. I don't know if I'd give it that description, but it's the cut and thrust. And, of course, a very important story. Can I also just add, Tim, I've seen a few commentators make the point, and it's an important point to make. But the criminal trial that Mr. Lehrmann went through, which, of course, was aborted at the end of the day, and the retrial, of course, didn't proceed. Very unusual proceedings in the sense that complainants in sexual offence matters are not normally identified.
Yep.
The entire background into what we're actually dealing with here in the defamation trial, it's a very unusual circumstance where, in relation to the criminal matter, the complainant was identified by name and picture. It's an important point to note, and it has, in my view, contributed, I think, to the heightened focus and awareness about this case. But it was highly unusual.
Because when that interview went to air, Mr. Lehrmann was not facing any criminal charges at all. So Ten and Lisa Wilkinson were able to name her, obviously with her permission, because she wasn't under any they weren't under any restriction under the law, because strictly speaking, she was just making an allegation, which, as you say, is highly unusual for someone to do a media interview before anyone's been even been charged. But from a media law point of view, and from Ten Network's point of view, that took away one of the potential hurdles in this story, because they didn't have to go to a court and apply, or to have any sort of suppression order lifted, or to put on evidence that the complainant in this case was happy for herself to be identified.
Yes, indeed.
Yeah, and when contentious stories like this come up, and we've had a few over the years, myself and yourself, I get asked a lot, "Oh, do you argue with the lawyers?" And I say, no, it's not arguments. At one level, it's a negotiation, and at the end of the day, your job is as you say, to assess the risk of a story and then give that advice to the editor of the paper that makes the ultimate decision whether to publish or not.
It's absolutely right, Tim. As I said earlier, I see my role as one. I'm not a roadblocker. That's not the role, in my view, of the media lawyer. It is to get the story out there, but to get the story out there in a way that is as safe as it can be, and that's in relation to all stakeholders. And one's always got to be guided at the end of the day by the rule of law, and those laws and principles are well known. And one, that's where I guess the experience and the expertise come. It's plotting a course through all of that in order to get these very, very important public interest stories out there, but in a way, as I say, that's as safe as possible. So yes, there are from time to time, hard discussion. That's perhaps not the right word, but robust discussion in the way of getting to that end result. And look, as I said, although only some baby steps on my part, having been a journalist, I understand that the story is it's like a journalist's child, right? I mean, it's something that's not to be interfered with. I mean, I completely understand that. So one starts from that premise, and it's the gentle guiding hand, and it's very much, I think, and as you know, with our interactions with doing things, it's teamwork. Yeah. It's teamwork, and we're all trying to get to an end goal. To win grand finals in the most efficient, effective way without too many injuries along the way. That's what it's all about.
Yeah. And would you agree, in this space, Australia has got some of the sort of strongest or strictest or defamation laws in the English-speaking countries? Well, I mean, the street talk always is, the cliche is, isn't it, that Sydney is viewed as the defamation capital of the world. Look, it is an environmental landscape, a landscape in Australia where, sort of my 30 years of doing what I do, there has been an escalation, I think, in the number of defamation matters that come along and hit the desk. But perhaps surprisingly to
to those who are listening in, these sort of matters that we're talking about today that hit the newspapers, they're the big ones, and of course they get the publicity. But they're just the tip of the iceberg. I mean, most of the matters that are before the courts or trying to be resolved off to the sidelines, as it were, they're between common folk, next door neighbours, sporting clubs, people at P&Cs around at schools, etc. I mean, these defamation disputes are common. People protect their reputations. They want to protect their reputation. Reputation is all important, and I think the obvious introduction of social media and the ability now for people to be able to publish widely, doing it on the basis that they think they're anonymous, that has escalated, I think, and fueled the increase that certainly I have seen in my experience in the number of defamation matters that do come across the desk.
Well, the fallout from this particular story was a predictable firestorm. The Morrison government was, at the time, also facing accusations of an old boys club, old school tie attitudes, and the elevation of Grace Tame to Australian of the Year had already placed the treatment of sexual abuse survivors firmly in the spotlight. And now, here was a young woman alleging rape at the very heart of Australia's democracy. The project had not named Bruce Lehrmann, and they now use that as one of their defences against defamation. But he claims his identity would have been clear and obvious to many of those who knew him and had worked with him. Nick, this question of whether Mr. Lehrmann was able to be identified by what the project had published is shaping to be a really key one. So talk us through the law there and what is he going to have to prove?
Yeah, so Tim, plaintiff in a defamation claim is there's three elements, three things they need to focus on to get up a claim. One, that something's been published about them, that there was in fact publication, and that what was published defamed them. That first point, that what was published was about them, is this identification point that you're talking about, and so it is a central element that needs to be proved. What I apprehend will be done, what's usually done, are witnesses put in the witness box who will give their evidence as to having watched the story on the project, and from the series of facts that they, because of special knowledge that they have about Mr. Lehrmann, that they were able to deduce that the subject focus of the story was him. So as I understand it, and as is usually the case where identification of the plaintiff is an issue, the various witnesses will have to give evidence, will get into the witness box and give that sort of evidence that they understood that this story was referring to and was about Mr. Lehrmann. So I think that those witnesses will be becoming family, friends, work colleagues, to give that sort of evidence. So at the end of the day, the question of identification may be one that might sound if Mr. Lehrmann wins this trial, it may have an impact on damages. That is to say, that it's only to those people who watched the show and who identified him. It's the assessment is made in relation to that pool of people, as opposed to a story which expressly names someone, in which case the person has been expressly named, so the damages are broader. So it may have an impact sound in damages. We'll wait and see.
And the other two elements there that you mentioned, the fact that it was published, I don't think that's going to be an issue, because we just heard two clips from the publication, and the fact that it was defamatory of him. I mean, obviously accusing a man of raping a young staffer in an office in Parliament House. I mean, you can't really get more serious allegations than that, apart from maybe what Mr. Rainey was accused of.
That's right, and it comes back to our discussion earlier that, of course, Lisa Wilkinson and 10 are running truth defences in relation to the defamatory meaning. They'll be able to establish the truth of that. Again, that's what this central feature of this trial, of course, and what the trial judge is going to have to get to the bottom of. based on the evidence that is on her hands. That is, very much, a feature of the case. So that's where the clash, as it were, of the counter allegations come into play.
Yeah, and that defence of truth and the fact that a judge in a defamation trial is basically going to have to weigh up a he said, she said scenario about a sexual assault and decide on not on the level of criminality, but on the level of likelihood that this happened. I mean, that's pretty rare for someone like Justice Michael Lee to have to wrap his head around.
It was experienced judge, self-evidently, presided, of course, most of it recently over the Heston Russell trial, I believe. Look, you don't know, there are matters that not only defamation ones, but commercial matters, etc., that do boil down to a contest of evidences between what one person has to say about an event or fact or matter or something that is contentious and a counter competing allegations, and that is the mission and task of the trier of fact, the trial judge in this case, to get to the bottom of that. So that's what they're to do, and they'll take all the evidence on board and weigh it up, and at the end of the day make a determination in relation to that question.
Yeah. And I am right in that, aren't I, Nick, that in this case Justice Michael Lee won't have to be convinced beyond a reasonable doubt, as a jury would be, but as close to that as he can possibly get, I would imagine.
Yes, correct. So we're at the civil standard, so the assessments that are made in relation to the evidence is assessed at the balance of probability. So it is a lower threshold than the beyond reasonable doubt threshold or test in criminal matters.
And another key point to Bruce Lehrmann's argument this week is that he was also not given a chance to respond to the allegations that the project were going to air. He says emails that he was sent weren't seen because they were sent to a sort of Hotmail account that he really used, and phone numbers that he was contacted on were not his anymore. So what's the significance of that?
As I said at the outset, my understanding is that qualified privilege defences are at play in this trial, in this case. That means that the focus in relation to those defences is the conduct of the media and whether or not the media's approach and the process and the operations that were deployed in putting the story together and at the time of the broadcast, etc., were reasonable. So, from that perspective, those defences are very much focused on on the media side of the ledger, how they acted and behaved, and what's in relation to that question, these sorts of issues, questions like the opportunities given to the plaintiff to respond to claims, etc., how that process unfolded, those sorts of things, very much the focus underpins the question of whether the sort of qualified privilege defences will stick or not. Mm-hmm. So those matters will be a central feature of that aspect of the case when it swings to Channel 10 and Lisa Wilkinson sides to get their defences out and up.
Mm. So Mr. Lehrmann claims that hour of television destroyed his life and almost ended it. In his affidavit in the trial this week, which was released by the court, he said he immediately contemplated suicide over what was being said about him. He was swiftly admitted into a psychiatric hospital for weeks and says his life has not been the same since. He's removed from the job he was doing then, dumped by old friends, ostracised by some family. And from the airing of that show, it took police months to investigate, amid a tempest of publicity which continued to swirl. In the meantime, some of the fringe elements of the internet news media printed his name and his picture. And in August 2021, he was charged with rape, and through that charge, more widely identified as the alleged Parliament House rapist. That trial was due to start on June 27 last year. But in the meantime, Lisa Wilkinson, the presenter of the project, had been nominated for a Logie for that interview. On June 19, 2022, 8 days before that trial was due to begin, Ms. Wilkinson won that Logie and proceeded to make a speech she had written herself.
As Brittany warned me before we went to air, her story would be seen by many of the most powerful people in this country, not as a human problem, but as a political problem. Brittany Higgins was a political problem, and governments tend to like political problems to go away. But Brittany never did. And the truth is, this honour belongs to Brittany. It belongs to a 26-year-old woman's unwavering courage. It belongs to a woman who said enough. It belongs to a woman who inspired more than 100,000 similarly pissed off, exhausted, fierce women and men to take to the streets right across this country to roar in numbers too big to ignore.
Nick, if an experienced journalist like Lisa Wilkinson came to you with this speech a few days before the alleged rape she was referencing was due to go before a jury, what would your advice be? Low risk, no change?
Tim, look, no doubt that there would have been, very considered observations and considerations made about in relation to this. It's difficult to say without being, to put oneself in the shoes of a factual situation which you're not entirely, being remote and satellite to it all, across. But suffice to say that, one can only but assume that it was a matter where the advice was, and no doubt was taken, careful consideration given to it all, and indeed there's likely to be, I would think, a matter that will find its way one way or another, perhaps into this current trial before His Honour Justice Lee, and we'll get more visibility on it. But as I say, from my own perspective, that's what we media defamation lawyers get paid to do, is to guide through and make the assessments and give the advice. But I keep coming back to the point, that's what we do. That ultimately we assist in the decision making by providing that advice, but the decisions are ultimately taken by the publish and broadcast, as it should be. Yeah. And we just part of that process that ends up in a publication or broadcast.
Well, the impact of that speech was that the Chief Justice of the ACT, Lucy McCallum, said that she was going to have to delay the trial, regrettably and with gritted teeth, she said. The prejudice of such representations, so widely reported, so close to the date of empanelment of the jury, cannot be overstated, she said. The recent publicity does, in my view, change the landscape because of its immediacy, its intensity, and its capacity to obliterate the important distinction between an allegation that remains untested at law and one that has been accepted by a jury giving a true verdict. And since then, Mr. Lehrmann's lawyer, Stephen Wybrow, has openly admitted that if not for that, a delay, he believes that his client may well have been found criminally guilty.
We made an application for a temporary stay. It wasn't fair, on top of everything else, for Bruce to have to face a jury a week after, on one interpretation. There were public statements again, basically saying Miss Higgins is a true victim of a true crime and the trial is just a formality. So we said we needed to have some time, we needed to stay in order to put some distance from that speech in the minds of any potential jurors. And the Chief Justice agreed and the trial was put off for 3 months. If it wasn't for Ms Wilkinson's speech, we would have gone into that trial without so much material that we subsequently came into possession of, either through chasing up disclosure or chasing up subpoenas, that was integral to properly understanding and challenging the complainant's allegations.
So, Nick, explain quickly what time to trial is and what's the importance of it, because it's one of the phrases that is we often use in our conversations together when you're looking at some of my stories and certainly other lawyers that we deal with at Seven West.
Yeah, Tim, the time to trial element is one that's important in the question of the contempt land. The general theory is that the longer ago a story was published or broadcast, the less likelihood it is to have an impact on potential jurors in terms of their capacity to recollect matter. Jurors who come along to do what they have to do in the context of the trial have to come along and make the decision based on the evidence that they hear in court, not what they've read or seen in newspapers or on the television. And the same applies in relation to witnesses. They're expected to come along to be able to give their evidence sort of free from contamination, as it were, by stories that are broadcast or published. So the theory is that the further away a trial is, then the likelihood of those sorts of impacts on jurors and or witnesses in a trial are less likely to impact. So the further a trial away is, the general rule is the more latitude, if I can use that word or perhaps license to report on matters that are going to be before the court is there and available.
And when that jury did finally convene, they heard evidence for 2 weeks. As foreshadowed by the Chief Justice, the central issue was the credibility of the complainant and whether her allegation of sexual assault can be believed. That jury then retired to consider a verdict on October 19 last year. 8 days later, they had still not reached that verdict. And ultimately, they never would, after it emerged that one juror had sought out and then brought into court a research paper on sexual assault, contrary to the judge telling them at least 17 times that they shouldn't conduct outside research. Ultimately, that criminal prosecution was abandoned altogether after ACT DPP Shane Drumgold declined to go ahead with another trial because of fears of Miss Higgins' mental health. And a subsequent public inquiry into the prosecutions was heavily critical of the way police and prosecutors had interacted, eventually leading to Mr. Drumgold being drummed out of his job. He has subsequently launched legal action against those findings. More firestorms, more recriminations. And amid it all, Miss Higgins was understandably distraught.
I was required to tell the truth under oath for over a week on the witness stand and was cross-examined at length. He was afforded the choice of staying silent in court, head down in a notebook, completely detached. He never faced one question in court about his story and the criminal charges. I was required to surrender my telephones, my passwords, messages, photos, and my data to him. He was not required to produce his telephone, his passwords, messages, photos, or his data. My life has been publicly scrutinised, open for the world to see. His was not.
You can hear the cameras clicking away there. The media interest was intense, as it was this week in Sydney's Federal Court before Justice Michael Lee. The judge, incidentally, who sat on the defamation rumble between Clive Palmer and Mark McGowan. This week, Mr. Lehrmann brought on his defamation complaint, which saw him take an oath and swear to tell the truth about what happened that night in Parliament House. As Brittany Higgins said, he didn't give evidence, he didn't have to give evidence in the criminal trial, but this trial is his trial, and so he was the first and probably star witness. His lawyer said he wants vindication, and Mr. Lehrmann gave his version of events under oath, that he never sexually assaulted Miss Higgins, that he didn't even speak to her or see her after they entered that office together. Emails were sent between them with no issue in the days after, he said. And after getting there, he has also had to get through cross-examination, which was going on and is going on as we speak this morning. And it's already seen him have to backtrack on some of his previous answers given to the AFP, given to an interview with the Seven Network, and given in court this week. Nick, even though the stakes are not criminally high, that questioning under cross-examination would still be daunting and is going to be potentially pivotal in the case that Justice Michael Lee has to decide on.
Look, indeed, Tim. I mean, the witness box. Again, in my experience in talking to people who've given evidence, I've given evidence. It's not really the place you want to be. But Mr. Lehrmann has obviously considered very carefully his position, and as you say, his lawyer has said that he wants vindication. So he hasn't taken the decision quite clearly lightly. Look, at the end of the day, the only advice you give to people who have to get into a witness box is you answer the questions. You answer the questions truthfully and to the best of your ability, but being honest and truthful. I mean, that's the guiding light. It is, it's a fishbowl environment. Obviously, I mean, this trial again, as I understand it, is being streamed live on a YouTube channel. So the eyes are on this trial and witnesses who are given evidence in the witness box as it's happening. But as I say, the mission of someone who gets in a witness box is to put everything else aside and listen carefully and what's being put and to answer the question, only the question, and to do it truthfully. And look, this trial and what's happened before it, it's been daunting for a lot of key players, of course, as we know, across both the criminal sphere and now in the civil sphere with this defamation trial, in the sense that the unprecedented media reporting, the proverbial discussions around barbecues and millions of backyards around the country. I mean, the people involved in matters, the lawyers, the judges, the witnesses, etc., been scrutinised wrongly, rightly, uphill, down dale in that sort of environment. What's the lesser of the two evils? I don't know. But as daunting as it is to get in a witness box, all those other things have been happening around it. To many, it's unfortunate. It's side play of these big, heavy focus media trials, etc. It's the Western democratic sort of system. It's what we have, and sometimes people get hurt along the way. But yes, it's difficult in trying.
Particularly, I would say, given the calibre of lawyer that Network 10 have employed. So 10's barrister is a man called Dr. Matt Collins, KC, and he literally wrote the book on defamation law, Collins on Defamation, which is published by the Oxford University Press. And Sue Chrysanthu has been separately hired by Lisa Wilkinson, and she's previously represented Christian Porter and Geoffrey Rush, amongst others. So, Nick, you've been around the traps. Have you come up against those two? And if not, would you fancy going up against those two?
Look, I mean, let's not forget, of course, on Mr. Lehrmann's side with Matthew Richardson.
Well, that is true. He's no slouch either. And
indeed, Stephen Wybrow, SC, I understand, also involved and will be front and centre too. I mean, there's no doubt these people are very good at their craft. I have had some dealings with some of them. They're entertaining people, smart people. They, as I say, they're very good at their craft. Don't forget, there's a very formidable bunch of lawyers on this side of the rabbit-proof fence too, of course.
Oh, yes.
So we're blessed with those as well. But yeah, look, at the end of the day, they're there to do their job and to do it well. And it's as I said before, it's the mission of witnesses simply to not be distracted by any of that and simply listen to the questions and answer truthfully and honestly. But yeah, look, they're high-profile figures, and they're good at what they do. There's no doubt about that.
Now, another action by Mr. Lehrmann against the ABC was settled before a ball was bowled this week. The terms of that settlement we are yet to learn. But it was also revealed that Mr. Lehrmann had also offered to settle against 10 almost a year ago for damages of $235,000 and an apology. But 10 declined and then apparently doubled down. And we learned this week they've even hired a lip-reading expert to find out what was said between Mr. Lehrmann and Miss Higgins in the bar before their trip to Parliament. Nick, that offer to settle, that might become significant later on if things go well for Mr. Lehrmann.
Yes, it has the potential, Tim. The system, that's the right word, of offers being made to settle and whether or not they're accepted and the reasonableness of conduct and people rejecting settlement offers may come back, be relevant in relation to the question of what damages are ultimately awarded. I mean, these are very sophisticated, tricky, difficult questions. Because there's a lot of crystal ball gazing that must go on when offers come in, and maybe that's underplaying it a little. There's a lot of heavy consideration that has to go into into these offers and when they're made, and at the time of when they're made, and there's the test of the reasonableness of a rejection of an offer, etc. That is something the courts grapple with. It is a very tricky, difficult question. So yes, look, it may come to have some sort of impact at the end of the day, of course, but depending on who wins, who loses, and by what amount and how much.
And on the flip side, $235,000 in the context of other awards in some of the other cases that you mentioned at the top is not at the top end, but from my reading of it, it was that apology that Mr. Lehrmann and his lawyers were demanding. I think that I'm not sure, I don't know, of course, but that might be the one that 10 balked at rather than them paying the money. And the damages in these type of cases, there is no tariff, and because I believe he's going for aggravated damages, there's also no cap on those, are there?
It's right. As the expression goes, Tim, the damages are at large, and the trial judge, at the end of the day, if he was to find in favour of Mr. Lehrmann and in making an award of damages, will assess a number of different things, and every case will turn on its own factual circumstances and what happened in a particular matter and the circumstances of the particular publication. So. Whilst other cases that have come before and awards that have been made are, maybe of some guidance, perhaps, it's an imprecise science. And indeed, the very conduct of the trial, for example, the way defendants go about the conduct of the defence of a matter, that is an element that may factor into an award of damages if the plaintiff does succeed. So, these are difficult exercises to be able to predict with any precision, which comes back to the point I was making about the difficulty in assessing offers, counter offers made, particularly early in the piece in matters, as to how reasonable they are at the end of the day, because the way these matters play out and the way they twist and turn makes it very difficult to be able to predict, as I say, with any real science and precision as to how a judge at the end of the day might make an award.
And look, this is probably an unfair question, but I'm going to ask it anyway. From what you've seen and heard so far this week, how do you think Mr. Lehrmann's claim is tracking?
Tim, you've allowed me the indulgence of the very important story of the client who said to his lawyer, if I ask you two questions and get advice on those two questions, will you cap your fee at $500? And the lawyer said, well, of course, what's your second question? Look, it's too early to tell, way too early to tell. This trial, I think, is set down for 4 weeks.
Yeah.
It will twist and turn, no doubt. We'll be keeping an avid eye on the reporting, and you'll be no doubt watching it on YouTube, etc. And I dare say the legal teams will. There'll be days when they thought they had a good day. There'll be days when they've considered that it hasn't gone so well. That's the cut and thrust of these sorts of trials. It'll ebb and flow. Way too difficult at this very early stage to be able to be able to say anything meaningful about how it's going at present.
All right, I'll let you get away with that one for now. The trial, as Nick said, is due to run until late December, and witnesses yet to come include Ms. Wilkinson, who has attended court in various shades of pastel this week, her producer, the former chief of staff for Linda Reynolds, a lady called Fiona Brown, and potentially Ms. Higgins herself. And, of course, Mr. Lehrmann has another case pending in another state. He has separately been accused of raping another woman twice in Toowoomba in Queensland in October 2021. That was just 2 months after he was formally named as Miss Higgins's alleged attacker. And he was only able to be named in that latter case after a change in the law in Queensland and then a ruling by a magistrate and a judge. Nick, thanks for joining us on Caught in the Act this week, mate. I've been threatening to get you on for since episode 1, so thankfully we've ticked that off. And as I said, we're going to check back when we have a decision on this matter, so you can pick through what happened and point out everything I've inevitably missed.
Good on you, Tim. Thanks very much, and thanks for being ever so gentle with me.
Yes.
Thanks again. Ciao.
And thank you for joining us again on Caught in the Act. If you have any questions or cases you want explored, then please email us at caughtintheact@wanews.com.au. And remember, if you want to know what's going on in court, don't get caught short. Get caught in the act instead. See you next time.